All right, now, who are both of you?
I'm his agent,
And who are you?
Samantha Chisholm,
And you spell your last name?
Chisholm.
And who are you?
Agent Curie Store.
Well, I recognize you, but how can you spell your name, please?
KIRISDORR.
All right. But I don't usually get to see all of you in person.
No.
I get to see you in writing. All right, okay. We will go on the record in the matter 16 CF38, 16 CF39, State of Wisconsin versus Jared Donatter. Mr. Donatter appears in person without counsel. We do have Department of Correction agents, both Samantha Chisholm and Iris Dorr. I can't say her name.
That's okay.
I'm sorry. They are appearing in person today for the probation review hearing. It appears by looking at the documents that Mr. Donatter has not made many payments and quite honestly is not making his regular child support payment in this case. He does owe a huge amount of back child support, roughly around $70,000 between the both of those cases. Who wants to give me an update on where we are and what you are asking of the court before I'm going to get to Mr. Donatter. Mr. Donatter, do you understand that you would have a right to an attorney?
Yes.
And you would have the right to have the attorney be here with you?
Yeah, I thought I had one, but
Nope, not after a public defender goes away after a short period of time, after the case is kind of resolved, and you were resolved by having a sentence hearing, and we sentenced you on March 26, 2021. At that time, you did have Attorney Lawton, who is now a judge, so he would not be able to represent you anyway.
Sure.
So you would need to reapply for a public defender. I know we extended probation last year on March 26th for an additional year, so it's coming close to having him discharged, yet it doesn't appear to the court that he is meeting his probation obligations. Is that correct?
Yes.
Who would like to provide me with a bigger update?
I can, Your Honor. So we're in a predicament with probation. Essentially, at this point, we're being a collection agency. We don't have the means to make him pay. We don't have the ability to force him to pay. I know revocation's been talked about, and quite honestly, we won't be successful in revoking him for not paying child support. We haven't been successful in it previously.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. This case is about far more than unpaid child support. A defendant owes roughly $70,000. Probation officers admit they're running out of enforcement options. And now the judge is preparing to step in with a completely different strategy. Instead of simply repeating the same warnings, she's about to use powers that could dramatically change the outcome. Watch closely, because every answer from this point forward will determine whether this defendant earns another chance or finds himself facing time behind bars.
The great thing is I understand, and I understand it sounds like you are a collection agency.
Mm-hmm.
And I really, truly get where Department of Corrections is coming with that. Where the court is coming is, quite honestly, he has not made regular payments, correct?
It does not look like it, no. But I think the county has a better means of forcing him to pay than we do, because we don't have that.
What I'm going to do, because this is what I love to do. I love to collect money. I like to collect money under probation because then I can do lots and lots of conditional jail. And that's what I'm going to do. So I'm extending you for an additional year because you have not made a good faith effort. And now I'm going to have regular probation review hearings, and I'm going to tell you what's going to happen now. Because you haven't been making your monthly payments, okay? I'm going to treat this kind of like my restitution court. You can speak with Miss Anibis about that, because I'm going to do that because this is essentially restitution. It is back paying for your kids' support for them to live and to survive. And so what happens in restitution court, and that's what this is going to be, is that the court now has a whole lot of other tools in my hands, a whole lot of conditional jail, a whole lot of other sanctions that I can pull, and I can say, you know what, DOC, I'm amending that judgment and I'm adding conditional jail. And that's what I can do. Because if you're not going to be paying, they may not be able to put you in a hold. I super duper can do conditional jail, and the law says I can modify and amend my judgment of conviction at any time to add conditional jail if you are violating. They may not have the tools and the power to do it, but I sure do. And so that's what we're going to do. So can you give me the last 6 months and his payments?
We've only got, I think, through November. We've not gotten anything more recent than that from child support. So I don't know if they're here and can speak to what his
Child
payments
support-
are.
Sorry, child support is here. And if anyone would like to come, or if you have anything to say as it relates to how many payments he's been making, I would so appreciate hearing that. We have Shelley Hatch from child support. Ms. Hatch, if you want to come have a seat over there.
Okay, so is this on?
Yes.
Okay, so going back to October of 25, which would be 6 months ago, starting with October, we got no payment in October, no payment in November. We received a payment in December, nothing in January, another payment in February, and then nothing so far this month. So, and it looks like he's supposed to be paying $200 a month in each case. We got $200 in December and then only $100 in February, so half the payment.
Okay, and so now out of all of the months that you listed, I didn't count. How many did he pay out of that amount? How many months? Did he pay a full payment
He made one full payment since October.
since October? All right, Mr. Donater, why aren't you making your court-ordered and probationary conditioned payments?
Well, we haven't been working much this winter and I don't have the money.
Okay, and I know you're self-employed, right?
Mhm.
What do you do?
Construction.
Construction? And so you haven't had a lot of work this winter? How many jobs have you applied to, like at, Subway or McDonald's or Dollar General or the Family Dollar? How many have you done?
None.
None? Ooh, so you could be working, you're just choosing not to. You're
Oh.
choosing not to continue to support your child, correct?
Sure.
Or children.
This is the turning point of the entire hearing. The defendant admits he didn't apply for a single job during a slow construction season, and that admission completely changes the conversation. In court, simply saying you don't have money isn't always enough. You often have to show you've made a genuine effort to earn it. That's exactly why the judge is shifting from sympathy to accountability. Do you think the judge is being fair here, or should financial hardship excuse the missed payments? Let us know what you would decide if you were sitting on that bench.
Right. So, see, that's where the sanctions are coming in, because you have to. You don't just get to sit on your butt and do nothing.
Right.
Your kids need they need clothes, food, shelter, extra money for activities, all of those things, right? Right?
Yes.
And so $70,000 is a lot of money to have back child support. The only way that can go away, because it's all back child support, correct? The only way that can go away would be for having your former significant others waive that. And I don't think that's going to happen. They could, I don't know. And so right now, I'm willing to see how it's going to go for 6 months with probation, because I don't want probation to have to. You're babysitting him paying, and I understand that things have changed a lot in probation over the years and what you're able to do, what you can't do. So I'm going to try this for at least 6 months, and then we'll see, because I do have tools. There are tools through child support agency and getting on purge, but obviously it hadn't been working. And so we're just going to see for 6 months. I'm extending you for a year, but we're going to see for 6 months, and then we'll see how it goes this way. And then maybe the court, I know you have to get Miranda. Is it Miranda's? She oversees you guys?
We're under Nicole.
You're under Nicole. Okay. So Nicole would have to sign off, and everybody would have to sign off to have them discharged off of probation prior to that year. But let's see how that goes, because otherwise we may have to open the toolbox with child support. But probation is supposed to be, a tool, and it's not, in this instance, it's not a really effective tool. That's not your fault. It's just the way it is and whatnot. So, Mr. Donato, here's what I'm going to do. I'm setting a hearing for 3 months down the road. If I do not see 3 months of full payments, then you're going to sit 20 days conditional jail, right?
All right.
So I'll amend the order, and it'll be 20 days conditional jail if taken into custody that day, if you don't have 3 months full payments. Okay.
Yes.
I'm also going to order, and I'm amending a probation condition here, that it's March. It should pick up maybe with construction in May, but you still could have a job. I'm ordering 4 job applications a week. Okay. So you have to do 4 a week, and you have to get those proof of those applications to Department of Corrections.
Yeah,
Okay?
but we'll be going back to work next week.
Full time?
Yeah.
Well, then if you're going to be full time, then you should be able to make the payments.
Yes, I will.
This should not be a problem.
Right.
Right?
Yes.
And I'm going to strongly encourage that you pay more than your required payments, because if you do that, then quite honestly, I'd be more apt to say, okay, let's take it back and have the court and the county handle it. Okay?
Okay.
Do you have Ms. Hatch, do you have the amount that is currently still owed?
Yes. So in court case, let's see, this one is 01 PA 27. The total of all debts in that case is $33,848.04. And then the other case is 06 PA 01, and the total of all debts in that case is $35,442.08. And I just wanted to say, like, one thing that he's been on probation for, I think, like 9 years. And so I'm really happy to hear that you're doing the conditional jail time, because I really feel like nothing much has happened in the last couple of years. And, he actually owes more now than he did 9 years ago.
Interest increases
Yes.
every day. It gets every single day. That's why it has to be paid off. I don't know your relationship with your children's mothers, but I think they'd rather have a big, huge lump sum payment, and they may be willing to waive some of that interest or all of the interest or whatnot. Because Mr. Donato, it's going to way over your head. And I'm going to tell you, I don't let up. Do I, Miss Hatch?
No.
No. Especially when it comes to children, because in looking at these are old cases, in 01 and an 06 case, but that tells me that the mothers had to do most of the taking care of or paying for the children's things. It's not fair to them. It's not fair to the children. Do you have a good relationship with your children, Mr. Donato?
Yeah,
Well, that's
sometimes.
Sometimes. Well, I hope you can get a better relationship with them. All right, so let's get a new date and time set. And you don't need to travel. You can appear by Zoom if you wish to do so, especially today with the roads. You're totally fine. If you want to come in person, that's great too. And I promise I will try and remember your names and how to say them. How do you say your first name?
Curious.
Curice. That's so beautiful. Okay. March, April, May. When is the payment due? By the end of the month?
Yeah, just within the month.
In the month. So we've not received March yet?
No.
So we haven't received March, so we're waiting for that March, April, and May payment. Good.
And if he's mailing a payment in, honestly, I mean, some payments take 2 weeks to get to Milwaukee in the mail.
So
So
you want to
just-
know the greatest thing about that? Because if he can mail it in and that's an option, the greatest thing about that is he can make a photocopy of the proof that he sent it. He
Yes.
can bring it to you. So
And he can always come up here with cash. Or, I mean, we're happy to mail it in too if he wants to come here. I don't think he lives around here, but, you know, and we have online, options as well.
June 3rd at 1. No, let's do June 2nd at 11. Does that work? June 2nd at 11. So that is 3 months, March, April, May, to have those paid by. Full payments. But again, you show me that you're doing more. We'll see where we're gonna go. Otherwise, the court is ordering 20 days of conditional jail. I'm staying that to see if you make these payments and we'll be good to go. Anything further?
This hearing ends with probation extended, strict new employment requirements, regular payment reviews, and a clear warning that 20 days of conditional jail could become reality if the defendant fails to make 3 consecutive full child support payments. Rather than immediately revoking probation, the judge chose to increase accountability through closer court supervision and additional enforcement tools. Cases like this remind us that family support orders aren't just financial obligations. They're legal responsibilities with real consequences when ignored. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and in-depth legal analysis. Thanks for watching, and we'll see you in the next case.
All right, then we are adjourned. Thank you.
Thank you.
Mr. Becker.
Mr. Donater, I've got your notice. There you go.
Thank you so much. Who do I have in custody?
The second one is at the bottom screen here.
Thank you. And Joseph Wells. Great. Okay, we will go on the record in the matter 26 TR 138, 26 TR 139, and 26 CF 23, State of Wisconsin versus Jamie Berg. The state appears through District Attorney Kevin Schmidt in person. Ms. Berg appears by telephone conference with approval of the court. Before we begin, Ms. Berg, I have a different telephone number for you. Is this your new number, 920-253-0199?
Yes, I live in
0199.
southern Wisconsin now.
Okay, all right. Well, doesn't mean you need to change your telephone number, but you did. 920-253-0199. All right, Ms. Berg,
Yeah.
have you applied for a public defender?
Not at the moment. I'm going to have to, but I still have my public defender from the Washburn County case.
But they're different. They're completely different. So what I'm going to do is you have to reapply. So Mr. Feliski, can you log in and can you talk to Ms. Berg?
Certainly, Your Honor.
Thank you. Ms. Berg, I'm going to adjourn the hearing right now, momentarily. And then I'm going to have Mr. Feliski talk with you privately through Zoom. And then he's going to see if you still qualify, and then he can get an attorney lined up for you for this case, okay?
Okay.
So as soon as I get him, I will send you in with him. Mr. Ramstrom, you don't qualify, I'm gonna guess, you don't qualify for a public defender? You may, you might. Okay, so Ms. Sherwood,
Yes,
are you able to do applications?
I can. I was actually just looking it up right now, Your Honor.
Okay.
If you qualify in our system. Mr. Rankin, want to come with me for 1 moment? Come see the phone.
If it helps for scheduling Berg, it looks like the Washburn attorney, she has a Zachary Fisher.
Okay, Mr. Fisher, that would help. Thank you so much. Ms. Berg, you may be able to get Mr. Fisher,
Yeah,
your
talked about
Washburn
it
County
before.
attorney, may be able to attach to this one. Mr. Felisky, can you hear me?
I can, Your Honor.
All right, she has Zachary Fisher in her Washburn County cases. So if she still qualifies and if there's a way, it'd probably be beneficial if she had him, but I don't know. You work your magic, you do your thing. I am going to send you both into a breakout session right now. There you go. Ms. Berg, you might have to hit a button or it automatically sent you. It sent you. All right, I have Mr. Reed. Mr. Reed, do we need to wait for Ms. Sherwood or could we proceed right now?
Yes, Your Honor.
Proceeding right now? It'll
No,
work?
no, if we could wait for Attorney Sherwood.
Oh, that's totally fine. All right, so you
Thank you, Your
can
Honor.
go back and we'll just wait momentarily with Ms. Berg. I'm sure Wells is with Mr. Plisky. All right, it's just going to be a little while before we get everybody moving, since we do need the PDs to do these things. So what I'm going to do is I'm going to put the court into the waiting room, and then when I come back, we'll be ready to go, okay?
Sounds good.
Close our rooms. All right, Ms. Berg, can you hear me?
Yes, I can hear you.
Back on the record, same appearances as previously noted. Mr. Joel Felisky is making a special appearance on your behalf. You do qualify for a public defender. Hopefully, you can request Zachary Fisher since he was the counsel, or he is your counsel in Washburn County. Were you able to go over the criminal complaint with Ms. Berg?
Your Honor, I believe she did receive a copy at this time, considering the circumstances and that she would like to get an attorney appointed. We would ask to have the initial appearance adjourned and rescheduled.
Tomorrow at 9:45. That's when Mr. Felisky, Mr. Fisher is here. So hopefully that will work to get him appointed to the case. And then we will go from there. Wait, let me see. Okay, tomorrow.
And I can call him too. I'm supposed to call him after the court today.
Yes, you can do that. I just want to verify that he will be here at 9:40. He will be. So you can call him after today. You can call the PD's office and see if they will appoint him for your case. But tomorrow at 9:45. Okay.
Okay.
All right. We'll see you then. Thank you.
Thank you.
All right. We will go on the record in the matter 23 CF62, State of Wisconsin versus Joseph Wells. The state appears through District Attorney Kevin Schmidt in person. Mr. Wells appears by video conferencing in custody in Burnett County Jail. We do have Joel Felisky, his counsel, in person. We're set for an initial appearance. Mr. Felisky, were you able to go over the criminal complaint with Mr. Wells?
I was, Your Honor. I believe he understands the charges here and the maximum penalties. We'll waive formal reading to the misdemeanor count, enter in a plea of not guilty. And then I believe he is requesting a preliminary hearing within time limits.
All right. Not guilty plea will be entered on your behalf. As to the misdemeanor. As to the prelim, wait, I don't even know. I guess I don't know if he's not even on a cash. No, we need to set bail first. He can pay $10,000 in the warrant, but it's a very old warrant. So Mr. Schmidt, argument for bond bail.
I would ask, I suspect the reason we did 10,000 warrant is that's the restitution. It's $10,043. I think that would be an appropriate amount given what's alleged here, which is more than one forgery. This is 29 counts.
Any more?
No.
Mr. Flisky.
A few points to make, Your Honor. Mr. Wells does have ties to the community here. I believe that he has family, including father, stepbrothers, and mother in the Siren area. He is currently indigent, Your Honor. I believe he was brought into custody. I think it's been some time since he's been in at the Burnett County Jail. So all to say, he has no ability to post anywhere near that amount. In review of Mr. Wells' prior history, it seems that this is the first and by far the most serious criminal matter that he has in the state of Wisconsin. I reviewed some of his prior history in Minnesota. It seems that apart from I have here a gross misdemeanor in 2012 would be the most recent and most serious criminal conviction. The other convictions that he has on record are quite old. They date back to, by my count, the 1999 at the earliest. He's advised that he's not currently on probation, Your Honor. It doesn't appear to have a history, given his history in Wisconsin, of missed appearances for court. In regards to why he did not appear prior to now, he advised that there was an issue with his address, which is why he made that did not appear initially when this case first started. Lastly, Your Honor, I'd note that he did advise he does have employment, full-time employment available upon release with Joe's Tree Service out of Coon Rapids, Minnesota. In consideration of the limited prior history, Your Honor, the facts and circumstances present here, I don't believe that $10,000 cash is the amount that's at minimum necessary for Mr. Wells to come back, to compel him to come before the court and to resolve this case. I'd ask for a $10,000 signature bond, perhaps with a $100 to $200 cash component, given the significance of what's being alleged here. Nothing further. Thank you.
Thank you. He is employed, or he could be employed from Joe's Tree Service?
My understanding is that he would have the job available immediately upon release, but that at this time he is not presently employed.
Victim is his father? Greg or George?
Yeah, George.
Is George your dad?
Yes, ma'am.
George is his dad.
He is adamant he wants absolutely no contact.
George wants no contact?
Yes.
Okay. All right. Well, I am not certain the facts of this case, at least at this time. So I'm setting a $5,000 cash bail, no contact with George Wells. Absolute sobriety, gainful employment when released, testing upon reasonable suspicion or arrest. Let's get the prelims set.
Would there be a 10% on that, Your Honor?
Excuse me?
Is there a 10% on that?
Nope, we are not in Minnesota. That's what Minnesota weirdly does, but nope, we are dollar for dollar. 1:30 on Monday, the 23rd.
That will work. Thank you, Your Honor.
All right, Monday, March 23rd, 1:30. We will see you then. We are adjourned. All right, Mr. Sunderland. We will go on the record In the matter 26 CF16, State of Wisconsin versus Dean Sunderland. The state appears through District Attorney Kevin Schmidt in person. Mr. Sunderland appears by video conferencing in custody in Burnett County Jail. We have Amber Sherwood in person and Ryan Reed by video conferencing. This is an initial appearance. Ms. Sherwood, have you went over the criminal complaint with Mr. Sunderland?
I have, Your Honor, and we waive its formal reading at this time and plead not guilty to the misdemeanor charges.
Not guilty plea will be entered on his behalf. Are you still in Jackson Avenue West when not in custody?
He is not, Your Honor. He has a no contact with that place. He is currently looking while in custody for a place to go when he gets out.
Okay, and so you're looking pretty hard so that you have a place if the court were to amend bond at some time?
Correct, Your Honor.
Are you on a probation hold or anything?
I
He
am
is not.
no.
He's only held on the bond here.
Okay, and it's a low amount, so there could be a motion to modify sometime. Hopefully, you can find some type of residence. Does your telephone end in 0904?
Correct, Your Honor.
He's been in custody almost a month, huh?
Yes, Your Honor.
Okay. So not guilty plea, we need to set a preliminary hearing. Is he requesting it within time limits?
Yes, Your Honor.
$145 on March 23rd. And that's all you got.
That works for me, Your Honor.
Okay, that works
The
for him. He's in custody.
145.
Your Honor, I
145.
believe I have court in St. Croix County. I'm not sure if I'll make it out before then. So I do have court in St. Croix County as well. On that date, I believe at 1 o'clock, maybe 1:30. I'm not 100% certain. Can I get back to you on it or my attorney?
You can talk to your attorney, but here's the deal. She asked it within time limits. That means you're stuck. That's it. Whatever happened in St. Croix County, you got to move that, not this. Or you have to ask to have this waiving time limits in writing and asking the court to adjourn it. If you're not in custody at that time, then that's what's going to need to happen. If you are in custody at that time, you can probably have your attorney in the St. Croix County work out with our jail to appear for your St. Croix County case by Zoom.
And
Right.
I checked CCAP, it's at 2:45, so I don't think it should interfere.
Okay, yours is at 2:45.
Okay.
All right,
you.
thank you. We are adjourned.
Thank you, Your Honor.
Thank you. Bridge LLC versus Stephanie Exendine. We have Scott. How do you say your last name?
Napke.
Napke, okay. Scott Nabke, who is appearing by video conferencing for North Star Mortgage. We have Ms. Exendine appearing in person. We're set today in this matter for a default judgment by affidavit. We do have Ms. Exendine here. So Ms. Exendine, first and foremost, I need to ask, are you opposing this matter or do you just want to be heard?
I just want to be heard.
I will allow you to be heard.
Okay.
So what do you want me to know?
I just want to know first of all that I wanted nothing to do with the house at all. I wanted.
And I think, I'm not sure if Mr. Napke is able to hear you. Can you put the microphone closer to you,
Sure.
please?
I wanted nothing to do with the house at all. I just wanted to leave. Has terrible memories. It was in horrible shape. It couldn't be fixed. It was just a mountain of things of debt just to fix it. So my husband had passed. He was the one that worked on the house, and I just want to be gone. Just get away.
That makes sense.
And so I was told after he had passed that I was a successor in interest and I would have nothing to do with it because of how it was either on the deed or the loan. I can't remember how it went, but I would owe nothing because of this matter, how it was being the successor. So I thought I was done with it. And then whenever this first set of papers came, I was served with them and I had 20 days to respond. And I flipped through the papers and I honestly, just till yesterday, did not see this one part on here, which is my fault. the part that says in written, they need to be, sorry,
That's okay. Take your time.
they need to have a response in writing. And I didn't see that. Like I'm holding it right here. It's literally on the written part. And I was just upset over it. And I had called my lawyer and he said, I shouldn't have any problem, but he never said anything about that part. So it's me not reading it thoroughly,
And you're
apparently.
here now, but I mean, this is a default. We'll get into all of that. But what is it that you would like Mr. Nabke to know?
That I did not do this on purpose in the 20 days. I had called the clerk of courts and they just said, oh, just go to court and this and that, you should be fine. And then I had called somebody from their company or whatever law firm and said the same thing. I want nothing to do with it. And they just reiterated that I wanted nothing to do with it. I said, absolutely nothing.
And I understand that. And let's just we can cut it short.
Okay.
And just, so you don't want the house. You
I
don't
don't.
want anything to do with the house.
No.
But what's your concern?
My concern is I don't want to be stuck with this $60,000. And that's what it looks like to me. I can't understand all this mumbo jumbo with legal terms.
Right. Yes.
I just don't want it to fall back on me.
Yeah. And so what you may have missed, and looking through the documents, usually in cases like this, not in every case, but in cases like this, especially this one with you, it does say in there that there won't be a deficiency judgment against you. Okay.
I saw that
Mr.
as,
Nabke?
I'm sorry, I just saw that in the part for my husband. I didn't see that with me.
And that would be with you as well, correct, Mr. Nabke?
That is correct. And just to even further clarify for the record, to substantiate what she has stated, Mr. Exendine was the only party that actually signed the note. So from a legal perspective, he would be the only one that we could have gotten a deficiency against. She never signed the note. She's not financially liable in any way whatsoever. So most definitely she is not on the hook for this. She was named as the defendant in the case simply because she signed the mortgage, and as she pointed out, she's technically the titled owner of the property with Mr. Exendine's passing. So we had to name her because there's no one else to name. But yes, we are waiving any deficiency judgment, so no one will be coming after her for money.
So do you understand now? And I know it's scary. I know, especially, losing your husband and having this house and then now having to rebuild your life and go somewhere else and then getting these documents and having what looks like a big bank coming after you. I can only imagine that you feel scared and frustrated and have anxiety and all of those things. And so it's easy to miss something like that or to not understand it. Yes, legal mumbo jumbo. We're taught in law school, sound smart. But they're not coming after you for anything. Okay?
Okay.
Do you feel better now?
As long as you said it.
And it is. It's all true. So is there anything else you would like me to know or just to say about everything that's been going on?
Is there legal fees?
You would not be responsible for any of that.
Nothing.
You're all
'Cause
good.
I saw
Good to go.
something for 3,000
Not for
something
you.
else. No.
Goes against the house.
Oh, okay.
Okay?
That's a big weight. Thank you. Because I'm not working at the moment. I had back surgery, so I don't even know if I can go back to my job. So I'm like, this would be great.
You are good to go.
Okay.
It won't be any harm or any debt or anything to
I was
you.
worried about the 20 days that it's going to screw things up.
Well, yes, you didn't necessarily even need to respond. I get why you want to. And if you would have said all of that in a response, quite honestly, it would still been able to be a default. Because that's not really any defense that you're saying in there. You're just kind of saying, this is my story, please hear it, and this is what it is. Okay?
Okay.
But now you have the assurance of Mr. Nabke, and you have the assurance that I've said it here in court today as well. So you're all good to go.
Okay.
Okay? Feel better?
I do.
Okay. Now go recuperate and be all good. Thank you, Mr. Nabke. I will make sure I get the document signed.
All right. Thank you, Your Honor.
Thank you. Have fun in Fort Lauderdale. Is that where you are right now?
No, so my law firm is headquartered there. I'm in Wisconsin, down near Milwaukee.
I thought
So I'm
that's
not
what I
enjoying
thought.
any nice weather.
I just thought you were like sharing time between, super Milwaukee. I don't know about Milwaukee, but we got like 2.5 inches or such of snow last night. But Fort Lauderdale sounds much better.
It does. I wish I was spending time there, at least like this time of year.
All right. Thank you, Mr. Napke.
Thank you.
Take care.